You're deciding whether to bring a wrongful death lawsuit for the death of a spouse or family member, and you want to know whether sympathy plays any part in the jury's deliberation when awarding you money. Come join me as I share with you the answer. Hi, I'm Gerry Oginski. I'm a New York Medical Malpractice and personal injury trial attorney practicing law here in the state of New York. The short answer is that sympathy is technically not supposed to play any part in a jury making a decision to award you and your family compensation. The reality is that at the end of the case, the judge and possibly even the defense attorney will remind the jury that sympathy plays absolutely no part in awarding a decision in whether or not you are to receive money for the injuries that occurred. Now, why is that? Because we all feel sympathetic when we hear of a tragedy. It's just natural. You tell somebody a story, something horrible happened, and we feel bad. But the reality is, an experienced trial attorney will get a jury to understand and have empathy and get them to visualize what has occurred to the family, to the survivors, as well as to the injured victim who ultimately gave their life. Now, that's an entirely different story than coming right out and saying, ladies and gentlemen of the jury, don't you feel bad? You should feel bad because of this horrible tragedy, and as a result of feeling bad, you should award my clients the following money. Well, we're not allowed to do that. But what we are allowed to do is to show to the jury, to visualize, to get them to understand exactly what happened to them, exactly what the pain and the suffering was, so that they have in their own mind an understanding of what this person went through. Now, we're not allowed to say to the jury, imagine if you were in their shoes. We're not permitted to do that. But instead, we can get the jury to visualize through witnesses and testimony exactly what occurred to the injured victim and what has happened to the family as a result of that loved one's death. So that's a key distinction. We're not permitted to actually use sympathy, and it can't be overt by any means. But once the jury understands and has a clear visual picture of what occurred, then they have the empathy and understanding. And then the jury will still be cautioned by the court that they are not to make an award based on sympathy. And we come right out and tell them, listen, this family doesn't need sympathy. They don't need that. They don't need a handout. They need full and fair compensation for the injuries that they suffered as a result of somebody else's carelessness. So that's a key distinction. We're not asking for somebody's sympathy. We don't want a handout. Instead, we want full and fair compensation for the injuries and the death that was caused that otherwise never would have occurred. So why do I share this information with you? I share it with you just to give you an insight and an understanding into what goes on during the litigation process as you're now considering whether to bring a wrongful death case on behalf of your loved one who died. And chances are, if you have questions and concerns, and I know you're watching this, so you most likely do, if your matter happened here in the state of New York, what I encourage you to do is pick up the phone and call me. I answer legal questions like yours every single day. You can reach me at 516-487-8207 or by email at lawmed10@yahoo.com. I'm Gerry Oginski here in New York. Thanks so much for watching.